Hello, and welcome to Schiff Hardin's presentation, If You Think Communications Between Independent Trustees and Their Counsel Are Protected, Think Again. We are pleased that you have decided to join us for this important topic. A copy of the presentation can be found in the handout section located on the left-hand side of your screen. Questions can be submitted at any time by using the chat feature in the lower left-hand corner of your screen. If time allows, our speakers will answer the questions at the conclusion of today's presentation. If we run out of time, the speakers will follow up by email to answer your questions. I would now like to introduce today's speakers, Marguerite Bateman, Stacy Hartman, and Dominic Puglisi. Dom, the floor is now yours.
Thank you, and good morning or good afternoon, everyone. Thank you for participating in today's webinar. If you think communications between independent trustees and their counsel are protected, think again, or as we like to say, the fiduciary exception to the attorney-client privilege and how it's changed our world. My name is Dominic Puglisi. I'm a partner here in the investment management practice at Schiff Hardin. And today we want to start by talking to you about a recent court decision, which I'm sure many of you have heard about, Kenny versus PIMCO, which has challenged our understanding of the scope of the attorney-client privilege and our expectations of how the privilege may be applied to communications between independent trustees of investment companies and their counsel. We also want to spend some time going into a little more depth as to just what the fiduciary exception to the attorney-client privilege is, how it's been interpreted, and perhaps most importantly, talk about what do we do now. In the Kenny case, a judge in the Federal District Court in Seattle ordered the production of certain emails between independent trustees of a mutual fund and their independent counsel, and in doing so, the judge cited the fiduciary exception to the attorney-client privilege. Now, after we picked ourselves off the floor from the chairs that we fell off of, we at Schiff Hardin have gathered our wits about us and have considered and thought about what this case means for our practice and for our clients. And I'm very pleased today to be accompanied by two partners in our practice group, Marguerite Bateman. Marguerite is a partner in the investment management group. Marguerite and I have had, unfortunately, 30 years of practice in this area. We have represented investment companies, investment advisors, but a majority of our practice focuses on representing independent trustees and directors. Our clients include small startup funds as well as larger nationally distributed retail funds, variable annuity trusts, and exchange-traded funds. Also pleased to have with us today Stacy Hartman, a partner in the Financial Markets and Products Group here at Schiff Hardin. Stacy is a trial lawyer who leads major cases both in court and enforcement and other proceedings before the Securities and Exchange Commission, CFTC, FINRA, and financial exchanges. She also represents clients in investigations by the U.S. Department of Justice. Stacy is, in fact, the Deputy Practice Group Leader in the Financial Markets and Products Group here at Schiff Hardin. So that's what this webinar is about, and we hope to spend the next hour with you talking in more detail about the case, about the exception, about what it means for us. Now, the fiduciary exception to the attorney-client privilege is familiar, frankly, to those who practice in the trust and estates area, but its application to the investment management space and in the context of derivative actions against asset management firms was completely unanticipated. And the rationale behind the privilege and the door that it opens raises frightening possibilities with respect to how it might apply in contexts, frankly, that go beyond the investment management business to any scenario where a trustee is acting in a fiduciary capacity. So let's start out by talking a little bit about the Kenny PIMCO decision, and we'll get into more depth about the actual decision in a few moments, but let me give you an initial overview. The case was a 36B case. As we know, in 36Bs, there are derivative actions claiming excessive advisory fees. The case was brought by a fund shareholder who was the plaintiff, and during the course of discovery, the plaintiff requested documentation from non-party independent trustees. Now, remember, in 36B cases, the defendants are typically the advisor. The trustees are typically not parties in the 36B case, so the trustees here were not parties to the action. The plaintiff sought emails of communications between the independent trustees and their independent counsel, and the emails sought information relating to contract renewal matters, trustee considerations with respect to onboarding new trustees or retirement policies, discussions about board meeting and committee meeting materials, the departure of some senior executives at the advisor, and other related material. The defendants in the case identified 200 documents that were responsive to the request, and they labeled those documents as privileged, and they were either redacted or withheld. In November, after hearing argument, the judge ordered the production of the documents, finding that the trustees clearly owed a duty to the plaintiff and to other shareholders. He noted that the privilege was not absolute, and he relied on the trust concept that we'll explore in more depth today, the fiduciary exception to the attorney-client privilege, and said the discussions and communications involved clearly appeared to relate to advice that the trustees received regarding the fund, as opposed, for example, to personal advice with respect to an individual trustee, and that therefore the shareholders, plaintiffs, were entitled to receive these communications. In so finding, the court noted and acknowledged the importance of the attorney-client privilege and the role it plays, but felt, as we'll explore a little bit later on, that on balance, the plaintiffs were entitled to receive the communication. Now, neither party, in briefing the argument, was able to cite any precedent in the investment management space for extending or not extending the fiduciary exception to the mutual fund context. Therefore, the court noted that it had no reason not to. A couple of interesting points to keep in mind as we talk further about this case. A mutual fund board of directors is, of course, very different than your typical trustee scenario because it's a collective of individuals. In a typical trust, even in an ERISA case, and we'll talk about one in a few minutes, a trustee is typically an individual. Here we have a group, and the group operates as a group. There was no discussion of that in the opinion. Here also there was a situation where fund and board counsel were the same firm. Again, don't know how that cuts either way, but there was really no discussion of that in the opinion. Now, as you might imagine, this provides an ample opportunity for plaintiffs to search in the discovery process. This exception has already been cited in another 36B lawsuit seeking emails from internal counsel for the advisor to a trustee. In arguing for disclosure of this information, the plaintiffs, number one, argued that internal counsel as an employee of the advisor did not represent the trustee, but also that even if that individual should be considered counsel to the trustee, the communication was not privileged because of the fiduciary exception. So we can certainly expect increased efforts to pierce the privilege in 36B cases. We know that there are more than 24 36B cases out there right now and various stages of discovery. This particular decision occurred in the Ninth Circuit. If it's appealed, it will be appealed to the Ninth Circuit. It is important to note that the Court of Appeals in the Ninth Circuit has found that the exception applies in the context of an ERISA action. So let me give you brief reminder before we get into more depth as to what the attorney-client privilege really is. Generally, the attorney-client privilege protects communications between a client and his or her attorney that involves the giving and receiving of legal advice. The privilege belongs to the client, not to the lawyer, and therefore only the client can waive the privilege. The purpose, as we all know, is to foster free and frank communication between the client and the lawyer, and this ability is believed to result in candid, direct advice and in optimal outcomes. It is considered, frankly, by many to be the most sacrosanct privilege in the legal world to protect clients. Let's remember some important misperceptions about the privilege, even before addressing the concept of the fiduciary exception. The privilege does not cover all communications between clients and counsel, only communications relating to legal advice. So to throw out perhaps a crazy hypothetical, a email from a trustee to his or her attorney saying, did you read the board materials? I think this is all a bunch of hoo-ha, might not be covered by the attorney-client privilege. Communication cannot simply be protected by labeling it as confidential or privileged. And finally, communication is never privileged if it's distributed by the client or by counsel to people outside of the attorney-client relationship. So as we've counseled over the years, over and over again, be careful who's on the CC list. Now a second on what the fiduciary exception to the attorney-client privilege is, and then we'll get into more depth on that. It is, first of all, a common law concept, not statutory, and it prevents the fiduciary from relying on the attorney-client privilege against beneficiaries seeking disclosure of the fiduciary attorney communication, where the fiduciary sought legal advice in connection with the exercise of his or her duties. The basis for the exception is that the fiduciary's duty is to administer the trust solely for the benefit of the beneficiary, and that takes priority. A key question, therefore, is whether the communication concerns fiduciary conduct, and that goes back to my example earlier of the comment by the trustee to his counsel, which arguably does not concern fiduciary conduct. Now, a finding that the exception applies does not result in a wholesale waiver of the privilege and therefore mean that all the documents must be disclosed to the public. Remember that the privilege is owned by the client, and therefore the disclosure is only to the beneficiaries who are perhaps the client in this circumstance. Now, this is a very inconsistently developed area of the law, and the existence of this exception and its application, even where it's recognized, differs around the country. Even in jurisdictions where it's found to exist, the application can differ depending on specific facts, may be applied differently in an estate scenario than in an ERISA scenario. But again, as we said before, prior to the PIMCO case, it had never been applied in the context of mutual funds. So with that as an overview, I'd like to turn it over to Stacy to get into a little more depth as to the theories that relate to the fiduciary exception. Stacy?
There are primarily two theories under which courts have applied the fiduciary exception. As Dom said, they are in different jurisdictions and the applications themselves have varied. But let's talk about these two predominant theories. The first is what's called the real client theory, and this holds that because the fiduciary is acting on behalf of and for the benefit of the beneficiaries, it's actually the beneficiaries who are the real client. This theory was first articulated in contemporary times in a case called Riggs, decided by a Delaware court in 1976, But for those of you on the phone who are history buffs, I'll note that this doctrine has its roots in 19th century English common law for trusts, and therefore it is long grounded, even if differently applied in more recent times. The other predominant theory that we'll talk about is the duty to inform theory, and this is likely quite familiar to a number of you who are joining us because this has a broad application across all of counsel's duties for fiduciaries. This finds that the fiduciary has a duty to disclose all material information to beneficiaries, and because something had been privileged would not excuse it from that duty. We'll talk about that case as well. That was originally espoused by the Fifth Circuit in 1970 in a case called Gardner. So let's talk first about the real client theory in a little more depth. Because the focus is on beneficiaries as being the real clients, this would result in communications between a fiduciary and counsel being deemed communications actually between the beneficiaries and the counsel. You can think of it in one sense as an application or expansion of the attorney-client privilege to include the beneficiaries among the client group, just as you also might include a fiduciary's agent within that group. It follows then that the beneficiaries, as clients who own the privilege, may seek discovery of those communications to which they effectively were parties if they are deemed the real client. This theory is particularly relevant in the context of mutual fund derivative actions, like 36B cases, as Dom recognized, which are brought by shareholders on behalf of the fund entity. The fund trustees arguably are fiduciaries to both the fund itself and to shareholders. When courts apply this real client theory, they generally use a three-factor test to determine who is the real client, and this has been used as a threshold analysis. One of those factors is who paid the legal fees. This is often considered a strong indicium of precisely who the client is. In other words, if you pay for the advice, it must belong to you. A second factor is whether there was an adversarial relationship between the fiduciary and those beneficiaries at the time the advice was sought. In other words, there was no reason for the trustees to seek legal advice in their personal capacity rather than in their capacity acting as fiduciaries for the benefit of the beneficiaries. And the third factor is the intended use of the communication between the fiduciary and the attorney at the time the advice was sought. If the communication was intended to benefit the trust and its beneficiaries, it's thought that that communication should be more properly shared with the beneficiaries as well. Once a court concludes that the beneficiaries are the real client, the court will apply a balancing test to decide which is more important, either preserving the policy of providing full disclosure in the trustee-beneficiary relationship or protecting the trustee's confidences with their attorney. That's a summary of the real client theory. Let me now briefly address the duty to inform theory. This is based on the notion that a trustee's status as a fiduciary imposes a duty by that trustee to the beneficiaries to disclose all relevant matter relating to the proper administration of the trust. As I said, this is probably a more common theory with broader application in the role of counsel to trustees. It's just being applied in this particular context for purposes of determining whether the beneficiaries are entitled to see communications between the trustee and its counsel. In balancing the competing interests between the policies underlying both the attorney-client privilege, as Dom had talked about, and the duty to keep beneficiaries informed, as the general duty we all know exists, courts have generally analyzed a multi-factor test to determine if there is good cause for applying the fiduciary exception to the attorney-client privilege. And that includes, among its factors, both the nature of the shareholder's claim and whether it's colorable, and the necessity or desirability of the information and its availability from other sources. Because the court is considering whether there's good cause for applying the exception, you can see how these factors both consider whether the shareholders are properly entitled to the information on the merits of the claim they've imposed, or whether the shareholders are simply on a fishing expedition looking for fodder to support their claims. Other factors that courts look at include whether the communication that's being sought relates to past or prospective actions, whether the communication relates to the litigation in question, which, as you can imagine, would guide its relevance to production, and also the risk of revealing any trade secrets or other confidential information that the corporation or the trust has an interest in protecting outside the context of litigation. A court may find that some, but not all of the factors apply when it is balancing good cause. And I'd like to note that when courts are trying to apply the fiduciary exception in the trust scenarios, they also consider the identity of the interest regarding disclosure among the beneficiaries, as well as whether the beneficiaries were directly affected by a decision that was made by the fiduciary based on the counsel's advice. With that background on the landscape of the law applying the fiduciary exception, Marguerite is going to take a deeper dive into the Kenny versus PIMCO decision. Marguerite?
Thank you, Stacy. The theories discussed by Stacy, both the real client theory and the duty to inform theory, would appear to provide a certain roadmap to the application of the fiduciary exception. As Dom noted earlier, regrettably, there's been inconsistent acceptance and application of the exception between states and between states and federal courts. For this reason, the choice of law question may be one of the most important in an analysis of the exception. We will be spending more time on this choice of law question a little later in the webinar. In Kenny, the PIMCO Total Return Fund was organized as a Massachusetts business trust, yet the case was brought in the Western District of Washington in Seattle. In reaching its decision, the court looked at the role of the trustees under both Massachusetts law and federal law and did not clearly align with either the real client theory or the duty to inform theory, to further complicate matters. In Kenny, the court acknowledged that the fiduciary exception had not previously been applied in the asset management context and seemed to acknowledge in its discussion the importance of the role of independent trustees and the relationship with their counsel. However, it did not go so far as to accept the defendant's argument that application of the exception would not work in the governing context for mutual funds, nor did it accept the fact that the independence requirements and the majority of independent trustees on a board would negate the need for the exception. It also did not latch on to the argument that there was a distinction between the business trust organization of the investment company from more traditional trusts. So there were a number of arguments put forth by the defendants that those of us in the asset management industry are very familiar with in discussing the independence issue, but that did not seem to carry the day. The court rather focused on the fiduciary relationship at hand and the derivative nature of the claims in this case. In doing so, the court made the point that the independent trustees, when that's discussed, are independent from the advisor. There is rarely discussion about the independent trustees being independent from the shareholders, who in this case, he would argue, are the beneficiaries. In reaching a decision that the exception applied in the Kinney case, the court noted a number of factors. One, that the investment company was set up as a trust, and that gave him license to bring in the trust concepts more readily. Two, the trustees owed a fiduciary duty to the shareholders, much as a trustee in any other context would owe to beneficiaries. Counsel was paid out of fund assets, which in this case, he argued, were the same as shareholder assets. Fourth, the communication that plaintiffs sought involved legal advice for managing the fund or the administration of the trust, which is the phrase that's commonly used in the trust context, not for personal advice. And lastly, that the communication from counsel was not made in the context of the counsel advising the trustee in the context of litigation, against that trustee, I should add. So we'll talk a little bit about where the court looked for guidance. The court clearly applied federal law. It looked to the Ninth Circuit as well as to the Supreme Court, both of which have recognized the fiduciary exception to the privilege. The court cited prominently two cases in its analysis, United States versus Met and United States versus Hickarella. The first case, the Met case, was an ERISA case decided in the Ninth Circuit in which the court noted that an employer acting as a fiduciary could not assert the attorney-client privilege against plan fiduciaries on matters of plan administration. In that case, the court looked at both the real client theory and the duty to inform theory in discussing the fiduciary exception. It explained, as Stacy noted earlier, that the exception has roots in trust law, but has been applied in numerous fiduciary situations. The second case, United States versus Hickarella, was decided by the Supreme Court in 2011. This case involved a breach of trust action by an Indian tribe against the federal government for mismanagement of funds held in trust for the tribe. The plaintiffs in that case sought certain documents between the U.S. acting as trustee and its counsel. Interestingly, while the Supreme Court discussed the fiduciary exception in this case, it didn't specifically rule on the existence of the exception. In fact, the United States government had conceded for the sake of argument that the exception applied, but was trying to make the point that it should not apply in the case at hand. In Hickarella, the court noted generally that the fiduciary exception bars the application of the privilege to withhold information from a fiduciary when the advice guides the administration of the trust. Again, that trust concept. It is not for the personal purpose of the trustee, and the privilege properly belongs to the beneficiaries rather than the trustees, and is intended to encourage full disclosure between trustees and beneficiaries. As noted, it's an interesting reliance on this case in Kinney, since the Hickarella case was not decided on the merits of the fiduciary exception. However, the cases cited by the Supreme Court in Hickarella do demonstrate that federal common law generally recognizes the exception. The basis seems to be that full disclosure in the trustee-beneficiary relationship should trump the protection of trustees' confidence in the attorney for the trust. Kenny's reliance on the Met and Hickarella cases and its focus on some, but not all of the factors under either the real client or the duty to inform theories, and the court's acknowledgement of, but failure to directly address the implications for communications between trustees or directors and their independent counsel in the investment company context, leaves us with less than a clear vision of how the exception may be applied going forward. So this, among others, there are a number of open questions that we have at the end of this case. One is, does the exception apply simply to trusts or to funds that would be organized as trusts, given the roots of the exception in the trust context? We do not believe that that's the case. The real gist of the exception seems to be, and the courts have supported this, the existence of a fiduciary and fiduciary-beneficiary relationship. So it could be that the exception would apply equally, and we expect that it would, to funds organized as Maryland corporations and indeed to many other fiduciary-type relationships. I will kick this back to Stacy for a discussion of some of the other open questions, including the choice of law question that I referenced earlier.
Because of the different application by different courts in jurisdictions around the country and both state and federal courts has varied so much, the application of the fiduciary exception through the choice of law analysis is really one of the most important questions to answer. It may also be, though, one of the most difficult to predict how it will be decided because, as is often the case, answering this question depends on specific facts and circumstances of each case. Let's talk about some of the considerations, though, that are used in a choice of law analysis. They include the jurisdiction in which the lawsuit is filed, what body of law the claim is based on, including whether it's an individual state's law or broader federal law, the jurisdiction in which the trust is organized, and also whether there is a choice of law provision in either contracts or other organizational documents for the formation of the trust. This particular factor is often a deciding factor because where parties have predetermined that a particular choice of law will apply, great weight is given to that by any court applying a choice of law analysis. Another factor that courts look at in the choice of law analysis is the location of the communication. And while that seems quite straightforward, if you think about it, could actually be multiple jurisdictions because trustees and fiduciaries may be in one or more jurisdictions. The counsel may also be in yet still other different jurisdictions. We've taken a sampling of different jurisdictions, both based on where trusts have been organized and also where particular states have decisions either applying or rejecting the exception. And let's start with state law. As of 2016, there's a statistic that 40% of funds were organized as Delaware statutory trusts. So it makes sense for us to look at Delaware trust law first. And it's notable that the fiduciary exception has been applied in both corporate cases as well as trust cases. Those same statistics show that 35% of trusts were organized as Massachusetts business trusts. Here, though, Massachusetts trust law does not have any cases that either apply or reject the exception, so not much guidance for that type of trust. Also, 16% of trusts were organized as Maryland corporations, and same as the case with Massachusetts, Maryland does not have decided cases either applying or rejecting the exception. The rest of the cases that consider the fiduciary exception are from different jurisdictions, but we wanted to note that New York law has applied the exception in both corporate and trust scenarios. If your clients find this fiduciary exception alarming, particularly as it's been developed recently, you might consider California trust law, which has affirmatively rejected the fiduciary exception. But if you're tempted to try to anchor your facts in California, obviously that will work only if the claim that's being brought is based on state law, because if it's federal law, it is more likely that the court will apply federal law to this privilege, and as has been discussed already today, courts have applied the fiduciary exception in both ERISA and other contexts. So now that we've raised your concern to an appropriately high level, if it wasn't already, let's discuss some practical solutions to consider.
Thank you, Stacy. So now what? Well, first of all, the easy pat answer might be pick up the phone. But that's easier said than done, both because of the way we've learned to communicate, but also because of some very other important considerations. A properly functioning board is a board that operates as a unit. The board needs to have the same level. Each board member needs to be apprised and aware of what's going on. There should be an open dialogue between each board member. One of the benefits of email has really been to foster that kind of communication. And it's easy to say pick up the phone and have individual discussions, but the risk there is that you lose something unless you have conference calls among all the directors all the time, and that's simply not going to happen. So I think you have to balance the need to be appropriately protective of your communications with the need to have a proper functioning board, a board where all members participate, are aware of things, and where all members can exchange ideas with their lawyer. And so it's easy to say, again, pick up the phone, but there's a danger there if you don't pick up the phone and have a conference call all the time, which, again, is not going to happen, which probably means that we will continue to have a healthy degree of written and oral communication. Now, I want to circle oral here because we've been talking about, emails and written communications, but the privilege, and therefore the exception to the privilege, applies to communications, not to notes, not to writings. And so oral communications will fall within the scope of both the privilege and the exception to the privilege. So it raises the specter of individuals being deposed as to discussions they may have had with their counsel. And it raises a lot of interesting questions about notes that may be taken during the course of calls with counsel, board meetings, and others. So we have always, and we will even more strongly in the boardroom, remind our clients about the need to exercise care in their written communications. Now, sometimes there will be a need to have, and there will be a need to have conference calls more often than there had in the past. But again, I want to just make sure that everyone understands that that should not be the end-all and be-all and should not inhibit the proper functioning of the board.
There could be a number of reminders or notes to think about as you consider how the case may impact your board and how it functions. I think the first is, just in the way of bolstering what you have in place. Many boards do have document retention policies themselves about those documents you keep, and for how long. That's always a good process to look at periodically and make sure that in the normal course you are following whatever policies you've adopted, and that may apply to board materials, to notes, to emails, to anything that, should there not be a privilege, could become public. In terms of strengthening those communications that you believe might be subject to a privilege or enabled to be protected by a privilege, you might consider, one, as Dom mentioned when we were first starting out, take care to whom communications are addressed. If you are sending an email to someone that contains, or if counsel is sending an email to someone that contains advice, it should be limited to those people who are, in fact, your clients. To the extent there is a broader distribution, then the privilege may be compromised. This also may go to discussions on email that you may need to be careful about email chains and who is in the chain of recipients on an email that you may forward. Also, in picking up Dom's oral communications concept, consider who is in the room when legal advice is dispensed. If it is a broader group than just clients, then you may not be able to assert the privilege in the first instance. And I guess a third cautionary note in connection with this string of protecting the privilege-themed items, just because a document has privileged written across the top does not make it so. It depends from whom and to whom the communication is directed. It depends on whom it may be shared with, and the document must include advice. It simply can't be a repetition of facts. So there are a couple of things there to cement or strengthen the ability to claim the privilege. As we think about, the fiduciary exception is in fact an exception in those cases where the privilege would otherwise apply. So the point was made in Kinney and in cases cited that the advice at issue was given in the administration of the trust. It is unclear from this case and those that it cites if advice given to a fund trustee could be segregated into advice relating first to the administration of the trust and separately advice on their responsibilities as a trustee. Interestingly, the documents that were requested in the Kinney case have the hallmarks of our traditional governance topics on a board, including, the election of trustees or the constitution of the board. So it suggests that it could be harder to parse the duties of trustees and to separate out those that are given in the administration of the trust and those that may be more traditionally thought of as conducting your role as a trustee. We would invite at this time any questions that you may have for us or for anyone on the panel relating to the fiduciary exception, and you'll be given instructions on how to submit those.
Thank you. As a reminder, to submit a question, go to the chat pod located in the lower left-hand corner of your screen. Type your question in the available box and click on the Send Submit button. It looks like we have a question waiting. I'll turn it back to you.
We do have a question waiting, and we will address it. But before we do that, I just wanted to ask Stacy to chime in on something. I noted with respect to oral communications, the specter of having notes of oral communications. A trustee calls his counsel and perhaps takes notes of what the conversation was about, or in a board meeting, in an executive session between counsel and only the trustees, trustee takes notes. Are the notes themselves, Stacy, do you think, perhaps discoverable under this exception?
If the exception were to be applied, then it would apply equally to any notes that reflect the communications as it would to testimony, either in a deposition or at trial, about those communications. But notes, of course, provide an additional complication because typically when they are taken by counsel, they not only reflect the privileged communications between the counsel and client, but also contain the mental impressions, analyses, and often strategies that counsel formulate in their own mind. And as we all know, that information is protected by the work product doctrine. There are fewer cases that apply, that deal with application of the exception to the work product doctrine, but in some of those cases, they have in fact applied the fiduciary exception equally and on the same bases to work product as other courts have applied the exception to the attorney-client privilege. So notes provide an additional complicating factor, but I think they are still subject to being discoverable where that exception is being applied.
Thank you. We'll now turn to some of the questions we've received. One of the first questions we received asks about whether the exception can be applied between communications involving internal counsel to the investment advisor, and I presume that means communications between internal counsel and the trustees. That is the scenario that I referenced in the beginning of the webinar, where plaintiffs have sought disclosure of communications between internal counsel and trustees, arguing both, number one, that internal counsel was not a counsel to the trustees, and even if they were, that the fiduciary exception applies. So, short answer is we don't know yet, but plaintiffs are making that argument.
Arguably, or an argument could be made, and I suspect it is the one that they will advance, is that the independent trustees have their own counsel. Internal counsel for the advisor would be, or could potentially have, a conflict if it were advising the trustees, and so given that, there is no attorney-client privilege. A further question that has been asked in connection with that is whether fund counsel, assuming they're not employed by the advisor, whether fund counsel communications with independent trustees would have the privilege or would be able to avail themselves of the privilege. And there's a stronger argument there. It has not been tested, but given that there is not a conflict between the fund or the trust and the trustees, there is a stronger case, we believe, for upholding the privilege in that instance. Though, again, it has not been put forth to a court that we're aware of, and so has not been decided.
Next question we have asks whether an email request for a conference call opens up the need to disclose the topic of the conference call. I don't know, Stacy, what do you think? To me, that is not a communication involving legal advice. It's a request by a trustee for a call. It seems to me at first blush that it's not privileged. As to whether someone can delve into as to what was discussed on the call, that perhaps runs into the whole discussion we've just had about the fiduciary exception.
Well, I agree, although I would say, and this may strike some of you as aggressive, that it's going to depend on what is put into the request for a call, conference call, meeting, or the like, because it's often the case that the subject for which advice is being requested is described in a way that, in fact, it would contain privileged material. In terms of whether any of that would need to be disclosed, just to perhaps review the order in which this situation is likely to occur, typically all communications that are either attorney-client privilege communications or contain work product would be withheld if they were otherwise properly discoverable. And then a privilege log would be prepared that identifies each such document with just some general categories that are provided for by the federal rules. And then the fight, as we saw in Kenny versus PIMCO, ensues, and there's typically briefing before the court and sometimes oral argument. And it is only at that point in time that the decision would be made whether any of that information needed to be disclosed. There wouldn't be a reason, if something is privileged, to disclose it unless ordered to do so. Coming back around, though, to your comment, Dom, if it is a vanilla, generic request for a call, it's unlikely that that in and of itself, it just says, imagine the communication says, can we have a call tomorrow? I agree that that would not in and of itself invoke the attorney-client privilege.
We have a question about the status of the PIMCO case. We don't represent and are not involved in that case, so we don't have any information as to the status of the case or any appeals. Question has been asked about how concerned should fund boards be about this. Should this be at the top of their next agenda? Marguerite?
On whether it should be at the top of your agenda, it depends what else is on the agenda. But the question is, how concerned should boards be? I believe that it serves as a reminder to all boards not to make assumptions that your communications are privileged and to take care in your communications. It's quite easy when you have not been the subject of a discovery order to not appreciate how lengthy, how painful, and how expensive it can be. So we encourage everyone to just use this as an opportunity to revisit the protections you already have in place and to think about your communications in the context of, consider before you write an email or before you prepare a memo, how would this appear if it were to be produced? Because we do have a degree of uncertainty here, and we would hope there are, as mentioned earlier, there are certainly needs to communicate, both in email and in written form, but taking particular care to ensure that communications that are advice are properly crafted, and those that are not advice and are not likely to be protected are not incriminating in any manner. Or I should say that in a different way, not that anyone would be communicating something that would be potentially the source of liability, but careless words or incomplete phrases can certainly be used against you if they are discussed in the wrong context. So the point here is to take care when you do commit something to writing that it is clear and is, to the extent possible, directed to only those persons to whom must receive the communication.
And that really rolls into a comment that we've received from someone noting that in many cases, communications involving trustees show and evidence the deliberateness of the process that they're employed in, their knowledge of what's going on with the fund, and really goes to the whole 36B defense of the expertise of the board. And so perhaps these communications, and now I'm putting words in the commentator's mouth, but perhaps these communications are not such a bad thing to have produced. And all of that is a valid point. Boards these days certainly engage in a detailed, deliberative process in doing their duties. But as Marguerite just pointed out, the concern is that we're talking in the context of litigation, and we all communicate in shorthand, and plaintiff's counsel will attempt to take and twist comments that may be sloppily written. So I think the concern is there. The point about the level of diligence that the board performs can be demonstrated in other ways, but it's a point well taken here that we're not worried about this because it's going to somehow evidence that boards are not doing their job. Quite the contrary, we're worried about this because of what plaintiff's counsel can mischaracterize these communications as.
And keeping in mind that the agenda, the materials provided for board meetings, and fully vetted minutes will go a long way to support the process that boards have followed and to support your contract renewal, et cetera. It is, as we've said, the stray notes and the incomplete emails or offhand comments that may be misconstrued.
A question that I don't think we have the answer to, Marguerite mentioned it during her comments, and that is how far does the exception apply outside of the trustee-counsel relationship? Specifically, the question asked about communication between internal counsel to the investment advisor to the investment advisor itself, noting the fiduciary duty under the Advisors Act that might be involved in this case. And I think, as you had said, Marguerite, before, maybe not.
Well, I think it would be subject to, this choice of law question that Stacy discussed, depending on the jurisdiction and the applicable law, and whether this exception would apply. I would think would be the same risk that you would have in any fiduciary context.
I think that's about all the time we have today. Sorry we didn't get to quite all of the questions, but we'd be happy to, have further discussions with anyone. You have our phone numbers on the first slide of the presentation. So if there's nothing else, I want to thank everyone else for participating.
Thank you. That completes our presentation for today. For CLE credit, please click on the evaluation link that is now displayed on your screen and complete it for your certificate of attendance. Please allow 4 weeks after the program to receive it. Thank you for your participation, and we look forward to having you back for other programs in the future. Have a wonderful day.